Well, I've got really good news for some of you. Juror number 64, where are you seated? Okay, not great news for you. Because any juror after 64, that is all of you, due to the kind of trial that we're having today, I do not think that we need all of you to stay. So jurors 65 and on, you will be allowed to leave. Hold on just one second. I told you from the beginning that we would be cognizant of your time and take care of you. We run an efficient court in here, and I hope you understand that. It seems to me that what people get most irritated about coming to jury duty is they feel like their time is wasted. I don't think we're going to get to the 65 and on, so I'm going to go ahead and let y'all go. If you would, here's the thing, you've now been through the process. And so when that person is at the mailbox beside you and they get that jury summons and they go, oh no, jury duty, how can I get out of it? I hope that your answer will now be, don't. It's important. It's worth it. They won't waste your time. They'll be efficient with your time. And those of you who have come, you've been a part of this process. Realize we can't get to this group that is left if all of you don't come. So it has not been a waste of your time to be here. Thank you so very much. Y'all have a great afternoon. And one more thing. It's all right. It's what? It's 10:25. I'm not going to call your bosses. So, if you've taken the day, it's all your time. Y'all have a great afternoon. Thank you for being here. Rudy, you ready? The court calls CR 23-2132A, the state of Texas versus Stacy Smith. Can counsel please introduce themselves to the jury?
Also introduced for the state, Victoria Brown for the defendant.
Philip.
Phil Huber for the state.
All right. The case to be about to be tried is cause number 23-2132A. It is the state of Texas versus Stacy Shawn Smith, who is charged with evading arrest with a motor vehicle. The punishment range for this charge as a third-degree felony is 2 to 10 years in the Texas Department of Criminal Justice and a fine not to exceed $10,000. It is estimated that this trial will take between 3 to 4 days. Now, you have all been seated at this point in a format that is intended to make the process completely random. That is because we were looking for 12 fair and impartial jurors who will sit in that jury box. This process that we're going through, all of jury selection, the questions that I ask, and the questions that the attorneys ask, understand they have one purpose, and that is to find 12 people who can be fair and impartial. And what that means is that you will make your decision based on only the evidence and the law in the case. And we'll talk more about that. Now, I need you all to stand again. Raise your right hand. Do you swear that you will give honest and true answers to the questions I ask and the questions asked by the counsel regarding your service as a juror? Yes. All right, you may be seated. All right, how the trial works, we already started a little bit. We have jury selection. That's what we are in right now. I will make a few comments. Then counsel for state will have the opportunity to speak to you and ask you some questions. Then counsel for defense will have that same opportunity. After they have completed, you will go outside. The attorneys will make their strikes. And at that point, we will return and tell you who the 12 jurors are. Now, I told you earlier that I thought that we'd be out of here before noon. That was my intention. That thing that we just did, that process, which is totally fair, that set us back a little bit, but you will be gone before lunch. Okay, it might just be a slightly later lunch. All right, we want you to have your afternoon. So the first phase of a trial is the guilt-innocence phase of the trial. During that phase of the trial, you decide if the state has proven their case beyond a reasonable doubt. And if they have done so, and you find the defendant guilty, we move to the second phase of the trial, the punishment phase of the trial. And during that time, the same jurors will decide what is the punishment. But realize there's two distinct sections. You will decide the guilt innocence based only on the evidence related to the charge that the state has made. Once you find that defendant guilty, and we go to the second phase, and you only find the defendant guilty if he is proven guilty beyond a reasonable doubt. If the state proves their case beyond a reasonable doubt, we'll go to the punishment, and then that is separate evidence that you can hear. That may be different evidence, that may be the same evidence. It depends on what the state puts before you and what the defense may put before you. That is their decision. Here's the thing. In Texas, the decision about whether the punishment is done by you, the jury, or by me, the judge, is made by the defendant. And that must be made in advance of us starting this process. And the reason is because if the judge is going to decide punishment, then we don't even have to talk to you about punishment. You do the guilt innocence phase and you go home. If there is a punishment phase that the jury is going to hear, then we will talk to you about punishment. In this case, the defendant and his attorney have elected to go to the jury for punishment, which means that you will make that decision. Now let's talk about how you will make your decision in this case. What I told you is that you will use the evidence and the law. Now the evidence, what goes into that evidence circle that you're looking at, comes from only two places. The testimony of the witness. The jury will be sitting in the jury box. The testimony of the witness is evidence. You will hear that evidence, and you will decide the credibility and the weight to give to the testimony of the person who's testifying to you. That's evidence. Number two are the exhibits that are admitted. That may be pieces of paper, that may be videos, that may be audio. I don't know what it is in this case, but only what is admitted becomes part of the evidence and goes in the evidence circle. So there's two parts to evidence: testimony and exhibits. Outside of that would be non-evidence. And you can't use non-evidence to make your decision. That's what makes this so fair, is that we come in and we ask you, can you make your decision based only on the evidence and the law? And once you have the evidence, then you will apply that evidence to the law that I give you. By the way, you don't have to know what that law is at this point. At the end, I will read you the jury instructions, and that tells you, here's what the law is. And the jurors will even take it into the jury room so that they know what it is and they can consult it. So you don't have to be doing any individual research on the law. But let's go back to the decision by the defense counsel and the defendant to go to the jury for punishment. Is that evidence? Well, let's think about it. Is it testimony or is it an exhibit? It's neither one. That would be non-evidence. And as I told you, you cannot use non-evidence to make a decision. You would throw out any non-evidence. And that's important here because in this case, the defendant in no way is suggesting that he concedes that he is guilty. Instead, he has to make this decision in advance. It's required under the Texas codes. So it would be completely unfair to hold that against him, the fact that he did what he's required to do in advance. And remember why that is. It's so that we can ask you questions about whether you can consider the punishment. If you're not considering the punishment, we wouldn't talk to you about it. It would be a waste of your time. That's why you find out now. But the fact that a defendant decides to go to the judge or jury, let me ask that question again, is that evidence?
No.
No. So you would not use it to make your decision. Now that's an easy one. There are other things that come up in a trial that you also should consider non-evidence. For instance, a defendant may not testify in the trial. Is that evidence?
No.
No. The defendant would be exercising his constitutional right. You know, you have the constitutional right to freedom of speech, and you exercise that through voting. But what happens if you don't vote? What do they do to you? Nothing. There are no consequences for you personally. The Fifth Amendment is a right just like that. And if the defendant says that he does not want to testify, or he and his counsel make that decision, it cannot be held against him. Right? Because that's a basic rule, but it's also what we're talking about. That would be non-evidence. Because the fact that a defendant doesn't testify, is that testimony? No. Is that an exhibit? No. That would be non-evidence. And you cannot use non-evidence to make your decision. So that's what I'm hoping you understand through these examples. They're very important ones. Another one, in cases, for instance, there may be, let's take a burglary case. If anyone has ever had their car burglarized or their home burglarized, they might have an experience there and go, you know, if someone's charged with burglary, I'm going to find them guilty just because I've already been through it. Now, would that be fair? Of course not. It'd be un-American because we make our decision based only on the evidence in that case. Now, if you say, look, my home's been burglarized, so if anyone's charged with it, I'm finding them guilty, you need to let us know. Because what you'd be saying is, I can't make my decision on the evidence in this case only. Right? And that's what we're bringing you here and asking you to do, is you weigh the evidence, the testimony and the exhibits, and you make your decision based only on that evidence. Another example would be officers, for instance. If you came in and you said, you know what, I believe in officers, so I'm going to believe everything that an officer says because I've had good experiences with officers. Well, you're already prejudging the evidence. Do you understand why? Maybe one officer that you had a great experience with, or the flip side, maybe you have an officer you had a bad experience. You can't come in and hold that against the officer who's going to testify, who you don't know. You will weigh the weight of an officer just like any other layperson. You'll listen to them and you'll weigh their credibility. And if you believe that officer, you can do it based on what you see, but not based on your past experience. Now, the question is, do we hope that all officers are going to be honest? Absolutely. But we can't make the assumption because then you would be prejudging the evidence. You look at an officer the same way you look at a doctor, the same way you would look at any other witness, including a layperson. That's the important thing to understand about how you're making your decision. You're not coming in with any preconceived notions. Now, in this case, The state must prove their case beyond a reasonable doubt. Now, what does beyond a reasonable doubt mean? There is no definition in Texas. What we know is that it is not beyond all possible doubt. It is beyond all reasonable doubt. And let me give you a quick example. If you knew something beyond all possible doubt, what would be your role in this case? Probably mean you were there. You saw what happened. You would be a juror. You would testify, and you couldn't be here. That's why it is not beyond all possible doubt. The rule is the state must prove their case beyond a reasonable doubt. And you will decide what that means. The state has to give an indictment in any case. Now, you remember the NBA basketball player in Russia or even better right now, the journalist who they showed behind a glass box. He doesn't know what he's charged with. We don't do that here. The state must indict their case. And all that does is tell the defendant, the defense attorney, and you what the charges are that the state is bringing against a certain person. The fact that the state has indicted anyone, is that evidence? The fact that they've indicted. Well, let's ask what are the grounds for being evidence? Either it came from the witness stand and it's testimony, or it's an exhibit. It's neither of those. The fact that someone has been indicted or charged with a crime is not evidence of guilt. You would not use that to make your decision. Because if you were using that, you'd be using something other than the testimony and the exhibits. The state must use the testimony and the exhibits to prove their case beyond a reasonable doubt. What that means is that if the state does not prove it on the state's own, their case beyond a reasonable doubt, you must find the defendant not guilty. But if the state proves their case beyond a reasonable doubt, you must find the defendant guilty. Those are the rules in the US, and they're wonderful. And that's what we're asking you, is if you can follow these basic rules. The defendant is presumed innocent. And that's for everyone who's ever been charged and ever will be charged, we hope, in this country. We can stick to this great program. The defendant is presumed innocent. That means that the defendant does not have to prove a thing, and he can still be found not guilty. The burden is entirely on the state. So what that means, as if the defense attorney doesn't ask a single question, I don't think that's going to happen here. But if the defense attorney doesn't ask a single question and doesn't do anything and just sits and waits, but the state can't prove their case, you must find the defendant not guilty. That's what the presumption of innocence is. We all come into court with this presumption that we are innocent. And only if the state proves their case beyond a reasonable doubt would you find someone guilty. Now, the last thing that I need to talk about with you is the range of punishment. And the reason that is that we have to make sure that you can consider the full range of punishment. Now, in some places, what they do is they say, if this is the crime, and this is the person's criminal history and several other factors, then this is going to be their punishment. This many years in prison or this kind of probation. That's not what we do in Texas. And that's awesome, because it gives you the power to decide how you want a crime punished. If you find, and only if you find the defendant guilty beyond a reasonable doubt, we'll move to that punishment phase. At that phase, the state can provide you evidence that is not only related to this case, but to anything else. Again, I have no idea what that evidence would be. And the state cannot tell you that evidence. We can't even talk about it, what we're going through right now. But if you find the defendant guilty of evading arrest with a motor vehicle, the range of punishment is 2 years to 10 years. So what we have to find out is that understanding that you have this awesome power where you could give 2 years or you could give 10 years, you understand that you will consider it. And here's the thing, you don't know how to answer the question right now of what amount of time or punishment you would give to somebody. Why not? Anyone know? You don't have any evidence, right? It all comes back to the evidence. You don't have any evidence. So you can't say, well, I think that in this case, if I had, no, you just have to say, I could consider the full range of punishment. Now, in that punishment phase, the state may give you other evidence, not just the evading case, they may give you other evidence. And if they do, you may say, that evidence makes me think that it should be closer to 10. Or they may not give you any evidence. You say, that evidence makes me think it's closer to 2. But you have that decision-making ability. You can't make it right now. You don't know the circumstances. Understand that. So I'm not asking you what you would give to somebody. That decision can't be made. But can you consider the full range of punishment? Is there anyone on my left, your right, in this section who could not consider up to 10 years for the charge of evading arrest with a motor vehicle? Very good. Anyone on the other side who could not consider up to 10 years in prison for evading arrest with a motor vehicle? Very good. Let's do the flip side. I have to know if you can consider the low end. Remember, same thing. You don't have the evidence, but you have the power to give the low end of punishment. Is there anyone who could not consider 2 years in the Texas Department of Criminal Justice for an evading arrest with a motor vehicle? I'm looking at my left, the right side of the room. Seeing no hands. On the other side of the room? Now, in some cases, let me close that loop. What I'm hearing is that all of you can consider the full range of punishment for this charge. Is that correct?
Yes.
Okay. In some cases, the state may come and they may offer additional evidence. This could happen in any case. I don't know what the evidence is going to be here. But the state could offer additional evidence of previous convictions, which would make the punishment 25 years to 99 years or life. They can only do that if they provide prior convictions that you believe beyond a reasonable doubt. What that means is that an evading arrest in a motor vehicle that is usually a third-degree felony could be turned into a 25 to 99 year case. Now that can only happen if the state can prove that there are 2 prior convictions who meet all the requirements. I don't know if that's the case here. I don't know what the evidence is. But you see where I'm getting. What that means is that if it could be an evading case and you get evidence that you believe that is beyond a reasonable doubt that shows that the defendant's punishment range is not 2 to 10, but 25 to 99 years or life, because it's been proven to you that there are prior convictions, could you consider 25 years to 99 or life for an evading arrest in a motor vehicle? Realize the punishment that you are giving is not just for that case that started out in the guilt innocence. It's for all of the evidence that you receive. But some people may say, look, at the end of the day, it's just about the evading. Understand, it's not going to be just about the evading, because the only way you could get to 25 to 99 is if the state proves other evidence to you. But let's say in this case or in any case, but we're going to do evading this time, because that's the case. If the state proves to you that there were prior convictions for which the defendant's range of punishment is 25 years to 99 or life, could you consider that full range of punishment on an evading arrest in a motor vehicle case? That is the question I have to ask you. Let me ask it then, starting on my left, the right side of the room. If the state proves to you beyond a reasonable doubt that the defendant is guilty, we go to the punishment phase, and they prove to you that there were prior convictions that meet all requirements, and you believe it beyond a reasonable doubt. The range of punishment could be 25 years to 99 or life. Could everyone on this side of the room consider up to 99 years or life? I see one person shaking his head no, and another person. Ma'am, please tell me your number.
7.
Can I have the new list? Not the shuffle list. Your number, ma'am? So
Did you say 7?
let me make sure that I've been clear. You have found the defendant is guilty in the guilt innocence phase. You've gone to the punishment phase. There has been evidence that you believe beyond a reasonable doubt that under Texas law makes the range of punishment 25 years to 99 or life. What you're telling me is that you could not consider that range of punishment. Is that right?
Yeah.
Okay. And it doesn't matter what the circumstances are, the evidence, you would never consider that.
It just seems ridiculous.
Okay.
Sorry.
Very good. That's number 7. Anyone else on this side? Ma'am, your number, please?
34.
34. If you'd hold it up for me, I'll get both. 34. Anyone else? Okay, number 14. Number 24. Number 42. And number 44. Did I get everyone on this side of the room? Realize I am not asking you to tell me what you would give to someone. That's not appropriate because we don't have any evidence. I just want to know if you can follow the law, which means that if all of those things are proven to you, it would be 25 to 99. And is it correct to say that jurors number 7, number 14, number 24, number 34, number 42, and number 44, if proven that evidence beyond a reasonable doubt of and all of the requirements, you could not consider 25 years to 99 years. Is that correct for all of you? Is there anyone who raised their hand that wants to change that position? Thank you very much. On the other side of the room, understanding that you cannot make a decision on what the range of punishment is, can you follow the law? That's what we have to know. Can you follow the law and consider the full range of punishment if the state has proven to you beyond a reasonable doubt, prior convictions, and all requirements that would make an evading case under Texas law go from 25 years to 99 years or life? Could everyone on this side of the room consider that full range of punishment? Is there anyone who could not? Very good. All right. Those are the questions that I need to ask. to make sure that you can be on this jury. Thank you very much for giving me your attention and understanding that everything that we are trying to do when we talk about the evidence and the law is for the purposes of getting 12 jurors who can be fair and impartial. Whatever the evidence is, you will listen to two things to make that decision: the testimony and the exhibits. Whatever questions you're asked going forward, if you can make your decisions based on only the evidence and the law in this case, then you can be on this jury. Please give your attention now to the state. Thank you for the attention you've given to me.
Good morning. I can tell the coffee's kind of wearing off. I get it. I also understand it's getting close to lunchtime, and if you hear a rumbling noise, don't worry. It's not the building, it's just my stomach, okay? So I'm with you. I'm ready for that lunch break too. But we've got a lot of important things we've got to talk about first. And one of them is a question that I always get asked by my friends and family when they get that jury notice in the mail. Because as proud as we are to be Americans, and as important as serving as a juror is, I understand that somehow the district clerk always seems to know the worst week to send that juror notice for you, right? And I totally understand that you guys probably had other plans for the rest of your week, and maybe they didn't involve coming and spending it down here with me and Judge Neidhardt and Defense Counsel. I understand. So if you're sitting there thinking to yourselves, I understand how important this process is, I'm a proud American, I'm happy to be part of it, but I would really like to spend the rest of my week doing something else, there is a dirty little secret when it comes to jury duty. You don't have to violate any conscience, you don't have to lie and pretend to be crazy. If you don't want to end up over here in this box, the only thing you guys need to do in the next hour or two is raise your hand and share your actual thoughts and opinions with us, okay? Because jury selection is not actually a selection process. What it is a deselection process. So of those of you who say, I understand the law, I can follow the law, and there may be some of you guys who say, you know what, I don't like the law, I want to follow the law, couldn't do it. Of those of you that are qualified, both sides get 10 strikes apiece. And the more you speak, the more likely it is that something that you say strikes one of us or the other, that maybe you're not the ideal juror for this particular case. Does everybody understand that? All right, well, now that I've let you in on the dirty little secret, let's kind of get started here. I want to make sure everybody here gets an opportunity to share their opinion, because we've done a lot of talking at you guys today, and a jury trial, when we get to the different phases, it's going to be a lot of y'all sitting there and listening. This is your only opportunity to share your thoughts and opinions with us. And in case you haven't realized it, this is one of the rare opportunities you will have in life to tell the district court judge, prosecutors, armed bailiffs, I don't like that law, and I'm just not going to follow that law. And not only does nothing bad happen to you, but we honestly thank you for sharing your opinion, and we let you go on about your day. So if you haven't seized that opportunity yet, and you fall in that camp, appreciate it, take advantage of it, okay? But for right now, I'm going to help you share those opinions. I'm going to get an opinion from everybody. There is no right answer to this question, but there is a right way to answer the question. And you've met the parties so far, but you've heard her referenced. This is Ruby. In all honesty, she's probably the most important person in this room right now. No offense, Judge. But the reason for that is because she also has probably the hardest job of anybody in this room right now. And that is to write down everything that everyone says. And that's hard. It's also hard to spell some of your names, which is why we have the number cards, because it's a lot easier to remember how to spell 22 than it is how you spell your last name, okay? So it's not meant to be depersonalizing, it just makes Ruby's job a little bit easier. The other thing that we can do to help make Ruby's job easier is make sure that we speak up. When y'all came in, Ruby made sure that y'all were sitting underneath some microphones. They'll help, but it will help us a great deal if you make that effort to speak up nice and loud for us. So what I'm gonna ask you to do, we're gonna go down the line. I want you to hold up that number card. Tell me the number that's on that card. Please don't take it. They do get deducted out of my salary if I lose them, okay? So hold that card up, tell me the number on the card, and then you're gonna tell me the number that best fits your response. And for those of you who maybe are having trouble reading it in the back, I think law enforcement in my community does a good job. 1, all the time. 2, most of the time. 3, some of the time. 4, rarely. 5, never. Okay? So we're gonna start down here. Juror number 1, start us off nice and strong.
Number 1, 2 most of the time.
Perfect.
Number 2, 3.
Awesome.
Number 3, 2.
3, 2.
4, 2.
Great.
Number 5, 2.
6, 2.
Number 7, 3.
7, 3.
8, 2.
Okay.
9, 6.
Perfect. Number 10, 2. Number 11, 2.
Number 12, 2.
13, 3. 14, 3.
15, 2. 16, 2. 17, 2. 18, 2. 19, 2.
20, 2.
21, 2.
22, 2.
23, 2. 24, 3. 25, 2. 26, 3.
26 was 3. Gotcha.
27, 2.
28, 2.
29, 2. 30, 3.
Okay.
31, 3.
32, 2.
33, 2. 34, 2. 35, 2.
36, 2.
37, 2. 38, 2.
39, 2. 40, 2. 41, 2.
42, 2.
43, 2. 44, 2. 45, 2.
46, 2.
47, 1.
48, 2.
49, 2. 50, 2.
51, 2.
52, 2.
53, 2.
54, 2.
55, 2.
56, 2.
57, 2. 58, 2. 59, 2.
62.
61, 3.
61 was 3.
62, 2.
63, 2.
64, 2.
Okay, good. None of my cards have gone missing so far. The judge talked to y'all already about a lot of really important legal concepts. We're going to spend a little bit more time going over it. But probably the single most important principle that we deal with in our criminal justice system is the presumption of innocence. That presumption is so strong that it does not matter the amount of evidence against you. You could commit a crime on video. There could be hundreds of witnesses, a mountain of forensic evidence against you, and you can have confessed. But in our criminal justice system, until and unless a jury is presented with sufficient evidence to find beyond a reasonable doubt that you actually did the thing you're accused of, that presumption of innocence is going to sink. Does everybody understand that? So if I were to ask you guys right now, is the defendant guilty or not guilty, what would your answer have to be? Not guilty, because you don't have any evidence at this point, right? Is there anybody who says that for whatever reason, I think I have trouble giving this defendant the presumption of innocence? Anybody at all? I don't see any hands on that. Judge also talked about the right not to testify. And this is something that we probably heard of before, but I don't know about y'all. When I was growing up in my household, there was no such thing as a Fifth Amendment. If I borrowed my dad's car and I brought it back and it had a scratch on it and he asked me what happened, and I said, I'm going to exercise my Fifth Amendment right not to testify, that was not going to fly. Okay? So I understand that this is a concept we may have heard about, But sometimes it's really hard to practically make it work in our world. And I'm sure most of y'all who have kids, if something happened and you were asking your kid what happened and they just decided not to talk to you, that would probably be a problem for y'all too, right? Raise your hand if you want to hear both sides of the story. Okay. Can we agree that that's probably the best way to understand what actually happened is to get both sides of the story, right? Well, why is it then that the defendant has an absolute right not to testify? Why do y'all think that was so important that we included it in the Bill of Rights? What do y'all think? Don't make me call on people, I hate it. I will do it if I have to.
So you don't incriminate yourself.
I'm sorry, you're number
49.
49, so you don't incriminate yourself. Okay, so that's great for the defendant. Why is it great for the rest of us? Why is it so important that we put it in that Bill of Rights? We made sure that every person has that. Even though we just all agreed that if you want to know what really happened, you want to hear both sides. What do y'all think? Is your number
59, so you don't jump to conclusions and automatically say, yeah, you're wrong, you got it.
okay? Yeah, we don't want to make any conclusions. What else? Any other ideas or thoughts?
I'm innocent until you prove me guilty. I don't have to say a word.
That's right. What's your juror number, ma'am? Juror number 11. 100% correct. Because who has the burden in a criminal case? The state. The state is the one that brings the charges, and we're the ones that have the burden. If we said we have to hear both sides of the story, what are we doing? We're pushing some of that burden over onto the defense, right? And that's not how our criminal justice system works. And some of y'all may say, that's great in principle, but I know myself. And if I were ever accused of something I didn't do, you wouldn't be able to keep me off that witness stand. And you know what? That's great for you. Guess where you are? Sitting over here, facing criminal charges. So even if you think that's how you might handle a situation, doesn't mean that it's fair to hold that against the defendant, right? So is there anybody who, for any reason, is going to take the fact that the defendant may or may not testify in the case and hold it against him? Anybody on this side of the room? Anybody on this side? Even just a tiny little bit? No? Okay, we're gonna hold y'all to that. Right to confront witnesses. This is one that we don't maybe talk about as often, but it has a really important role in this courtroom. And one of the things that you will see as you go through this process, the judge told you, you'll hear from witnesses on the stand. Common sense tells you that in any criminal case, probably gonna have some of those officers or some of those witnesses be police officers, right? Guess what jurors never get? A police report. Do you know why? Because you can't confront a piece of paper. The state has to bring you the actual witnesses to get up on that witness stand. And the reason for that is because the defendant is entitled to confront the witnesses against him, and you guys as jurors have to assess every witness's credibility. The judge told you everybody's got to start the same, whether it's a police officer, a doctor, a mechanic, school teacher, everybody starts the same, right? And it's up to you as jurors to judge their credibility. You decide who you believe, how much of what they say you believe, and what weight you're going to give it. That's all going to be up to you. And that only happens if the defendant has that right to confront witnesses. Does everybody understand that? And for the love of God, when you guys go back to deliberate, no one's going to send a note out asking me for the police report, right? I'm pretty easygoing, but that one will annoy me. So the right to subpoena witnesses. Now, we already decided this. Who has the burden in a criminal case? State. What does the defense have to do in a criminal case? Absolutely nothing. Ms. Vicki Brown over here could sit here and not ask a single question of any witness. She could waive any argument and just wait for me to fall on my face. Nothing wrong with that. Now, do I think she'll do that? No, absolutely not. Vicki loves giving me a hard time. So, right to subpoena witnesses means that the defense does not have to call a single witness, but they have the same power and authority as the state does when it comes to compelling a witness to come to court or getting a piece of evidence the same way that the state might. So they don't have to do it, but if they choose to do it, same power and authority. Does that make sense to everybody? Does anybody have any questions about basic rights that we've gone over so far? Right to 12 men and women who can be fair. Now, what does it mean to be fair? It means holding me to my burden. If at the end of the day, when you go back and you consider all the evidence and the law that the judge gives you in that jury charge, if you have a reasonable doubt about whether or not the defendant committed the crime that I'm accusing him of, your job, your responsibility as jurors is to find him not guilty. Can everybody agree that they will do that? It is not a popularity contest. It is not a matter of whether you like the defendant or you think he's a good person or a bad person or anything else. It is not a matter of Philip stole your parking spot this morning and you're very upset with me still. It's not a question of Vicky looks like your favorite aunt. The decision and being fair means holding the state to its burden. Can everybody agree that the decision they make in this case will be based on the evidence and hold me to that burden? Okay. So, when we talk about evidence and what beyond a reasonable doubt means, I never liked the definition that we had. I'm always more of a visual person. To me, evidence starts a lot like this. It's a bunch of jumbled puzzle pieces. If I were to ask you guys, what do you think this is going to be when those pieces get assembled? What do y'all think? Don't say a puzzle. We don't know it's a puzzle. But what is it going to be a picture of? No idea, right? How about now? Can we tell what it's supposed to be now? How can we tell it what it's supposed to be even if there are pieces missing? I'm sorry?
Most of it's being told.
58, most of it's being told. Is there anything about the pieces that are missing that are going to change the fundamental image itself? No. This to me is a lot like what beyond a reasonable doubt means. Okay? I guarantee you, you are going to have questions at the end of this trial. I have never gone back and talked to a jury, even a jury that came out 5 minutes with a guilty verdict, where they have not had questions. Something's still outstanding that they didn't have answered in their minds. That doesn't mean that the state hasn't met its burden. So when you go back to deliberate, what you're going to have to ask yourself is, do I have a doubt? Is that doubt reasonable? I'm going to suggest to you that if the defendant did it or it had to be Bigfoot, probably not a reasonable doubt there, okay? And third, does that reasonable doubt go to one of the elements that the state has to prove? And so let's talk for a minute about the elements of evading in a motor vehicle. The judge told you that this is the law in this particular case, and we're going to talk a little bit more about the actual elements. This is kind of the checklist. This is what you're going to be asked at the end of the day. Did the state bring you the evidence to check all of these boxes? I have to prove that the defendant is who I say he is. That the offense happened in Hays County, Texas. And that the defendant, while using a vehicle, and yes, it must be a motor vehicle, intentionally fled from S. Starburg. Now, intentionally, let me ask you guys. Do I have any time-traveling psychics? I'm still missing those lottery numbers then. If we don't have any time-traveling psychics that are going to end up on this jury, how are we ever going to be able to figure out what was someone's intent in the moment? How are we going to do that? Juror number one, what do you think?
Actions dictate intent.
Actions dictate intent. So you're going to look at someone's actions. Perfect. Anything else? Mindset, I want to give credit. Give me your number. 44? 44. Mindset. How can you tell what someone's mindset is? Awesome. Circumstantial evidence, right? We do this all the time without even thinking about it. If someone bumps into you in the hall, your brain's working. You're figuring out, was this an accident or did they intend to do that? We're gonna look at their actions. We're gonna look at the circumstances around what happened before, during, and after to help us figure out what someone's intent was. And when we talk about something being intentional, what we mean is that it's not an accident. Does everybody understand that? Does anybody have any problem being asked to figure out what the defendant's mental state was at some previous point in time, knowing that the one person who absolutely has a right not to testify is the defendant? Can you figure this out based on someone's actions, circumstances, the evidence? Can everybody do that? Okay. An S-starter was a person the defendant knew was a peace officer who was attempting lawfully to arrest or detain the defendant. These are the elements for evading in a motor vehicle. So my question for you is, why is this a felony? What do you think? I didn't write the law. The legislature did that, and they also wrote themselves an exemption from jury duty, right? So if you don't like the law, if you don't think it should be a felony, that's fine. Raise your card, we'll write it down. But my question to y'all is, why do you think they decided to make it a felony? I'm sorry, picture number 44, 45.
I was gonna say the same thing, if it's other people at harm.
Okay, other people at harm. I'm sorry, what? I want to give people credit, so make sure you pull up your number for me. Your number 57. And themselves in danger. Is there anybody here who thinks that this shouldn't be a felony offense? It should maybe be a traffic offense or a misdemeanor? We're treating it too seriously. Yes, your number 14.
I don't think it should be a felony.
Okay, fair enough. Your number 42.
I think it depends on other factors like speed.
Okay, well, we just went through the elements of what the state has to prove. Did we see anything that had to do with speed, distance, duration, that somebody had to be in danger because of it? Why do you think when they wrote that law, they didn't make that a requirement? What do you think? You're number 22.
Because everyone would run.
Because everyone would
You
run.
have to be stopped with question.
Okay, so just generally, everybody has to stop.
If you're got a cop behind you with lights on, yes.
Okay, and if you don't do that, you agree should be a felony offense.
I don't know if it should be a felony. Circumstances.
Circumstances, okay. Yes, you're number 4, what do you think?
I think felony's too harsh. If there was a crime involved, maybe, but just leave 2-year minimum.
Okay. Why do you think they wrote it so harsh though? Are the legislators just mean? I mean, they might be, I don't know any of them personally.
If it wasn't a felony, number 56, if it wasn't a felony, then people would take it too lightly, and so many people have died because of the circumstances that they needed to make the charge.
Okay. Well, how about this? If somebody's just fleeing from a police officer and they're doing it on foot, or I guess on a scooter, if it's a non-motorized vehicle, it is just a misdemeanor offense. The fact that this is a felony offense is because there is a motor vehicle that's involved. Does that maybe change people's idea of why it becomes a felony? You're number 63.
I think it comes down to public safety,
Okay.
you know, that's bottom line. The difference between somebody on foot or a motorcycle or motor scooter as opposed to somebody in a 2,000-ton vehicle, there's a big public safety thing there.
Okay. So even if maybe there's not a requirement to prove that somebody was in danger, just the nature of the crime itself, you believe is dangerous.
Yes.
Okay. Yes, you're number 45.
Motor vehicle is a deadly weapon,
Motor vehicle is a deadly weapon. What do you mean by that?
that it can cause, death or great bodily injury.
Sure. How many of y'all drove your deadly weapon down here to the courthouse today? Okay. When y'all were sticking the keys in the ignition, were y'all like, okay, this deadly weapon, I need to gas it up later, like. Most of us, we don't think of our vehicles as deadly weapons, right? I mean, I don't remember Honda running any ads about, ours is the deadliest weapon out there with the, best gas efficiency. We don't think of motor vehicles as deadly weapons, but can they be? Absolutely, right? Unfortunately, most of us have seen, or sometimes even experienced within our family, a death that resulted from a motor vehicle accident. These are serious things. What I want to make sure everybody understands is that the law and what I have to prove to you beyond a reasonable doubt are just the elements that we went through earlier. I don't have to prove that the defendant went a minimum speed or a particular distance or that it lasted a certain amount of time. Those may be things that affect the second phase of trial if we get there, punishment phase, but they don't affect the guilt-innocence phase. Does everybody understand that? Okay. Is anybody going to require that I prove to you a certain speed, duration, distance that was traveled before you would be able to find beyond a reasonable doubt that the defendant evaded? Yes, you're number 36.
I mean, I guess the distance thing, I mean, if they're just pulling out of their driveway and they see a cop like down the road, they don't know particularly if it's like for them or not. Maybe they're just backing out of their house, see a cop with the lights on. Either house or across the house, they don't particularly know they're being, it's them that they're after, I guess.
Well, let me ask you this. If I've convinced you beyond a reasonable doubt, and we'll go back to the elements, that the defendant knew that that officer was there attempting to lawfully detain that person, that defendant, and he fled. Does it matter how far he fled or?
If he knew.
Okay, so that might be some of the elements or the circumstances that help us figure out what someone's intent was, but there's not necessarily a hard line that I'm gonna have to prove to you on that one specific day. Is that correct? Thank you. Yes, sure, number 44.
Ironically, on the way up here, I saw a police officer on I-35 drive approximately a mile till he could get to a safe place to pull over. He hit the wrong officer one day. He was sitting in that seat over there. But the intent was safe. Officer interpreted as evade.
And that's part of why we have this system, right? Is we don't want that one officer to be able to make that decision of what that person's intent was, right? We want to be able, we don't even want me as the prosecutor looking at this case to make that decision. We want 12 citizens with all the common sense and your life experiences to look at that evidence and make that decision. Because that's what being fair in this process means, okay? So yes, absolutely. There may be a situation where an officer believes that, this person intentionally fled. You looking at all that evidence may say, you know what? I don't think that intent was there. I think someone was just getting to a safe place to pull over. And in that case, has the state met its burden? No. And what would you do? Find a non-guilty, right? Okay. So we already skipped ahead a little bit. This is actually the legal definition of deadly weapon. Is there anybody here who thinks that a motor vehicle could never be a deadly weapon? I don't see any hands. So I see you all drove here on 35 at some point. What about how someone drives can make a vehicle a deadly weapon as opposed to just a normal means of conveyance? What are some of the things that you're going to look at that help you figure out whether that vehicle, in the manner of its use, was capable of causing serious bodily injury or death? Your number 59?
Speed and the way that they are handling the vehicle.
Okay. Speed and the way that they're handling the vehicle. Anybody else? Your number 48.
Driving erratically, weaving in and out.
Weaving in and out of traffic. How about just the fact that there's other traffic on the road, right? I mean, don't get me wrong, the very few times, late at night or early morning when there isn't traffic on 35, I get a bit of a lead foot, right? And driving, not to put on the record what speed I sometimes drive, But that may not be a dangerous thing if there aren't a lot of other vehicles around. Whereas if it's a bunch of traffic and I'm having to weave through, that might be a different situation, right? Anything else? Yes, sir, number 43.
Yes, ma'am. Stop checking people on the freeway as if people doing sudden stops. Make the person in back of the stop in a sudden manner.
Okay,
Yes, ma'am.
so realizing that there are other vehicles that have to respond to how you're driving,
Yes,
okay? And making sure that they have appropriate time to respond safely.
yes, ma'am.
Yes, sir, number 51.
People pay more attention to their phone while driving.
Are they on their phones while driving? That's a big one.
Yep.
Yep, that can definitely be something. So someone who's distracted by something else while they're driving, that could potentially make a motor vehicle a deadly weapon. So we all kind of see how we're using kind of circumstantial evidence to piece together the puzzle here. Is everybody comfortable with that? All right. Now, how many people have watched a show like this, Law and Order, something like that? Who's gonna admit it? Go on. Okay. And for those of you who are laughing and turning your nose up, how many of y'all watch or listen to something like this? True crime. Okay. Now, why are both sets of these shows up there together? Because this is the real world. We are not a podcast. We don't have someone from Dateline coming in to do our hair and makeup. I've talked to my elected about it. He says we don't have it in the budget, okay? We don't get to edit things for your entertainment. And because of that, we're going to ask that you not hold us to the standards. Whether they're the imaginary standards of CSI, which, for the record, has been banned in my household because I yell very loudly at the TV when it's on, or whether it's any of these true crime shows. You do not get to hold us to these standards, okay? Everybody agree to that?
Yes.
Okay. Now, the judge told you in this particular case, you are going to be asked to assess punishment. And we are one of the few states that actually does that. In almost every other state, it's up to the judge to decide sentencing. Texas is unusual in that sense. The important thing to realize is that because we have two different phases of the trial, the type of evidence that you hear in those two separate phases is different as well. So during the first part, the guilt innocence phase, what's the ultimate question that you're going to be asked? Did the state prove it beyond a reasonable doubt, right? When you get to the punishment phase, you don't get a really clear-cut question like that. You get that range of numbers. And you have to figure out where in that range is appropriate. Now, in order to do that, you need to know a lot more about the defendant than his actions on one particular day, right? You need to know the good, the bad, the ugly. That's when you get to hear that information. You do not hear it in guilt innocence phase. You hear it in the punishment phase. And the reason for that is because in the guilt innocence phase, the burden's on the state. I have to prove you did it. And if you were a teacher and you were asked to grade a student, and you gave a student a C, because, well, he got a C in the last, 5 years, he's always gotten C's, and you didn't grade his work that particular time, is that going to be good enough? No, absolutely not. So, when it comes to the punishment phase, you get to know the good, the bad, the ugly. Judge has already talked to you guys about the range of punishment, special circumstances. I know some of y'all were right out the gate. I could not do that. 25 to life on a case like this, could not do that. 25 years is longer than some of y'all have been alive. Okay? I understand that that is a big, scary thing. I want to make sure that you guys can honestly consider, in the appropriate case, for this type of offense, that full range of punishment. Whether it's 2 to 10, or if the state proves beyond a reasonable doubt those special circumstances that the judge talked about, 25 to 99 years or life. Because I don't want to put anybody over here in this box because that is going to be asked to do something that they fundamentally feel uncomfortable with, or they have a moral or religious objection to. So again, if you already talked to the judge, great. But is there anybody else who cannot consider that full range of punishment in the appropriate case? Juror number 44, got you. 34, 42. Anybody else who did not already talk to the judge? Over here, juror number 56, could not consider the full range, is that correct?
I have a hard time with it. It feels like it's awful extreme for a decision that took place. Hopefully there weren't people didn't die of this. That would affect it. But if it was just a bad decision, I have a hard time between 9 years to life.
And I think that's fair. I would hope most of y'all are in the same boat. I can't get into any of the underlying facts. All I can ask is, could you consider some set of facts in your mind where you would be comfortable in that case, not necessarily this case, but in that scenario in your head that you could consider doing the 99 years for life?
If the circumstances, since I don't know the circumstances, I would have to say, yes, I guess I could, because I don't know this.
Perfect. That's all we're gonna ask. And if we can't get into the nitty-gritty details, the judge told you some of those special circumstances. It could be, someone's prior criminal history, if they had any. It could be sometimes where an offense happens. Sometimes if we're talking about a drug offense, if it happens in a school zone, that raises our range of punishment as well. So you don't even know what the special circumstances are that would raise that minimum range of punishment to 25 to 99 years for life. Yes, juror number 4.
The only real way to answer that honestly is to know the type of circumstances that occurred. If you're saying in that stage, we're gonna find out who murdered somebody previously, then absolutely. But you would have to be something
Okay. As long as you can come up with some scenario in your mind where you could say, I could consider it, not even I would give it, just I could consider it, then you're a qualified judge. So nobody else is gonna have any heartache over this. Okay. Now I always find myself forgetting to ask sometimes basic questions. One of the ones that has come up before is sometimes people, for their religious reasons, cannot sit in judgment of a fellow human being. Is there anybody who, for religious or moral reasons, would not be able to deliberate and render a verdict in a criminal case like this? Juror number 34, that would be you. Okay. Anybody else? Juror number 14, religious or moral reasons you could not render a verdict in a case like this? Okay. Remember, Ruby's got to be able to write it down, so thank you. Anybody over here? Anybody I missed? Anybody who's sitting there thinking to themselves, gee, I would be a terrible juror for this type of case, but I just haven't been asked about my particular issue yet. You're number 41. Is that something you're comfortable sharing, or would you rather do it up at the bench?
I could go either way. Want to hear it, I'll say it.
It's whatever you're comfortable with.
Well, there's history of law enforcement in my family, starting with my dad in the Austin Police Department. His brother, my uncle, retired as captain in the Austin Police Department.
Okay. So a lot of experience in law enforcement in your family.
There was influence in the young neighbors.
Okay. Not even going to ask which way that goes, because sometimes it goes either way, right? What I am going to ask you is, as far as you know, they're not going to be coming to testify in this case, are they?
No.
So can you wait and assess the credibility of any officers or any other witnesses equally?
I have to think that it could have some influence on my opinion.
Okay. Do you think you would give law enforcement officers more credibility just because they are law enforcement officers as opposed to any other witness that might testify?
Yes.
Fair enough. And what was your juror number one more time? Juror number 41. Got it. Juror number 34.
strange to some people, but it's very hard for me. I'm a very big procrastinator. It's very hard for me.
I'm sorry, I can't hear. Would you mind standing, please, ma'am?
Yes, sir. I'm a very big procrastinator, and it's very hard for me to make decisions. Even as a kid, there is a syndrome, I don't know exactly what it is, I read something about it, and it was years ago, but even as a kid, my sisters would always say, it takes you an hour to make decisions during one campfire, another campfire. So I would not, it is very difficult for me. I feel such a heavy burden, and also really small, loyalty, which is judging others, after 71. So, it would be really hard for me, difficult for me to put that type of burden.
And your number 34, I appreciate that. Thank you very much for sharing. And I hope you don't take it personal that none of us go to lunch with you later, because we're going to be on the clock again. For those of us who make that story. Anybody else who has something, and if you're not comfortable sharing it in front of all your new best friends, if you wanted to approach and take it up at the bench later, that is absolutely fine too. Anybody else? Your number 61, is it something you want to take up at the bench later? Okay, thank y'all very much for your time and attention. I look forward to presenting my case to the lucky 12 adult who end up in the very comfortable seats over here.
Okay, at this point, I always think it's helpful. Is there anyone who couldn't do another questioning by the attorney without a bathroom break? You want to keep moving. I like it.
We got one in the back.
You got one in the back. Well, I want you to be able to focus. Okay, so everyone stays. I mean, you can stand up and stretch. If you need to go to the bathroom, go, but we can't start until everyone is back. So go ahead and go very quickly, come right back, and the rest of you can stand, stretch, relax. How you doing, Ruby? We're all here? All right. Well, thank you very much. That was good timing. Defense, are you ready to proceed? Please give the same attention that you gave to me and to the state to the defense attorney. Ms. Brown?
Women's clothing, it's not very conducive to putting some thoughts out there with me. Onto my list. All right. So before we get started, I don't know if you've seen us up here thoroughly writing down notes and thumbing through your juror cards. The reason we do that is both sides. We like to know a little bit about you as jurors, what's your background, you know, not when we talk about your feelings, et cetera, but we also like to know about any type of historical knowledge you have that you might bring into the trial. You know, sometimes you have some type of scientific evidence, we find out maybe it's chemistry, it's a blood lab. We find out that you work in a blood lab somewhere and you bring that knowledge into the jury room and you completely disagree with the expert who's up there testifying. And sometimes that can make the trial not fair, sometimes be helpful. But the bottom line is, as the judge went over, you only consider the facts you hear at a trial. And so if you have some kind of special expertise, sometimes it can be inadvertently misused in the trial. So I asked a few of you a little bit more about your background before we start the feelings and opinions, et cetera. Juror number 3, Ms. Hill, you're a forensic scientist. What particularly do you do? Toxicology, okay, for a Texas DPS lab. So she clearly has some expertise that she might bring into the trial, right? And I guess that would be the question. Would you be able to set aside your specific knowledge that you have and consider facts perhaps that aren't in evidence in case a witness maybe didn't testify about something that you know about? And would you be able to set that all aside and only consider a case on the merits of what you hear? You could do that? Okay. All right, number 5, Mr. Tang.
Yes.
You're retired, so I don't know what you did.
I'm semi.
Semi-retired. So what's your expertise?
On the hospitality industry.
Okay. I wish they said, you know, if retired, what was your former job? We wouldn't have to ask you all this. All right. Number 12, Mr. Clark, you let us know you were retired as well. What have you done in your former times?
I'm sorry,
What was your former career?
I was military and then, oil field security.
Okay, what did you do in the military?
I was in the Navy.
Right, your tech, ET, or what were you?
I was a torpedo man and weapons.
My husband's former Navy, so that was a JAG, so I kind of, all right. Number 20, Mitchell, Mr. Mitchell.
Yes, sir.
You said that you were retired as well. What was your former career?
Construction, treated concrete.
Awesome. And then next to you, Ms. Flores, you're also retired?
Yes.
What's your former career?
I was a registered nurse.
Okay. So you're probably not really retired. I'm sure everyone calls you all the time with their aches and pains, right? All right. Juror 30, Ms. Anderson, you noted that you were retired. What was your former career?
I was a full-time maker. Also, unofficially, husband, personal assistant in his office work.
What did your husband do for a career? What was your husband's business?
A lot of different things went on it. I just did all this.
Okay. So strong administrative executive assistants. Okay. And Ms. Abrams, juror 34.
Yes,
What was your career?
child nutrition department.
I'm sorry, repeat that?
She said child nutrition. Is that correct, ma'am?
Yes, ma'am, I was a child nutrition.
Thank you.
And then Ms. Kelly next to her.
I was at a University of Texas system. I was a landman.
Well, what kind?
Landman.
Oh, landman. Okay. That's when you go out and you pull all the deeds and everything, right? You did that for UT? Was that?
Yeah.
Okay. I never heard the term landman until I moved to Texas. Okay. And Mr. Harris, you're 44.
SVP for a car wash platform.
I'm sorry, can you repeat that?
It wasn't clean.
Sir? I'm sorry.
Ruby's got to take that
Can
down.
you repeat that, please?
Yes, SVP for a
S,
senior vice president for a car wash platform.
thank you.
You're the boss. Okay. Juror 44 was the boss. Gotcha. All right. Ms. White, you didn't list a job that you had?
I was a legal secretary, but I've been a homemaker for 20 years.
So when you were legal secretary, what kind of law firm or office were you working in?
It was mostly civil. I mean, it was.
Civil, as opposed to criminal, that we're not civil people. Gotcha. All right. And then, Ms. Scott, you're 55, you noted that you were retired as well.
Yes, executive, administrative secretary for
Investments, okay. And then juror 63, Ms. Odom.
Customer service.
Okay. And then juror 60, Mr. Long.
Retail sales.
I'm sorry, what, sir?
Retail sales.
Okay. All right, thank you. Yeah, I'm sorry, just about my housekeeping. Okay, Stacy, stand up, please. This is Mr. Stacy Smith. He is the defendant in this cause. We're gonna have Steve. And we are the defense team, and you also have met the prosecution. Nobody out here has had any legal work with me, have you? I do family law as well. Sometimes we have represent family members or the other side. They definitely know about that, because sometimes people don't leave the courtroom happy, whether they be your client or the other side. But nobody knows about any of us up here from any former life and former representation. Okay. Alrighty. So last trial I had, my clicker didn't work. Uh-oh. Oh, it's doing it again. Hang on. I spoke too soon. I might just be clicking my own stuff here. All right. So what is voir dire? State talked to you a little bit about it. This is the voir dire will speak the truth. It's the only time in the criminal process that you, as a juror or potential juror, get to ask us questions, get to talk to us about things. Otherwise, you have to sit and listen. And it's really important for us to know, as the state already told you, and I hope not to be repetitive here, but sometimes certain trials are just not the right ones for you. Maybe you were involved in a chase on a highway where it just upset you so much that there's no way you ever want to sit on a maybe arrest case, okay? It's more so like really if you like a burglary habitation, if your house just got burglarized the night before, a burglary case is not going to be the best one for you. Or maybe you had a situation with family where you felt that they weren't treated fairly in the justice system, whether they be the victim or the defendant. And so you have a strong feeling one way or the other towards prosecution or the defense, that you just can't check at the door when you come in. You can't ensure either side of fair trial. So that's why we do this process, okay? And my favorite slide I use all the time. Who's on the stand? Who's testifying? Okay, and who are his jurors? Yeah. So do you think he's going to get a fair trial? I mean, you may have your opinion, you may say yes, but in the justice system, do you think he's going to get a fair trial? No, of course not, because of what he did to the dogs. And so similarly, that's what we're trying to figure out here is what, here we go, now it works, what we can do. So there's no right or wrong answer, okay? You have to be entirely honest with yourselves and with us. Because what we don't want to have happen is, it's going to be a pretty short trial, is have one of you 12 up there go, you know, if I'd only told them this during voir dire, they'd know, because now I can't sit as a juror. Maybe it's that you know a witness, or something comes up to your mind that, oh, I should have told them that, or that's really how I feel. Now's the time to do it, because if you do that, then it's a mistrial. We have to do it all over again, okay? Even if that does happen, I'd still encourage you to be honest about it, and still know you're having some issue about something you've got to tell us. But it's very, very important that you're honest during this process. So, we've all heard about wrongful convictions, right? I mean, who's never heard that someone's been wrongly convicted before? And we all have, right? And a lot of that came about with the development of DNA, because, you know, the DNA doesn't lie, essentially. And why is that important in a particular case? It happens because a lot of times, criminal convictions, they rely upon who did it, right? The case of mistaken identity. Or maybe, how do you get there? Maybe there's like a false report somebody makes against that person that they have in the justice system. And maybe there's just bad investigations that end up having people be wrongfully accused. Y'all agree with me on that? I mean, it happens. That's, you have a justice system. Sometimes the evidence comes out later, but it happens. And that's why it's so important that we get it right the first time. So let's talk about that first thing that could result in perhaps a wrongful conviction. What factors do you determine when you're trying to figure out who done it? We don't have DNA. Well, that's the first juror. Mr. Number one, Deblet? Okay. If a case is hinging upon an eyewitness identification or like who did it, what kind of things might you rely upon if it's an eyewitness that's going to have to tell you?
I mean, the quality of the witness, if they're where they were in like, I guess where they were when they were reviewing the crime being committed. If they were a mile away, it's hard to pick up details.
Okay.
Like vicinity.
All righty. Mr. Nicholson, juror number 2. Can you give me any factors that might help that you determine the reliability of an eyewitness identification? Who done it?
I guess like any biases they might have.
That when you say the eyewitness biases?
Yeah.
Against the person that's being blamed?
Yeah.
Okay. Ms. Hill, juror 3.
I'm sorry, I can't hear.
Like the circumstances of how, like, how close to the situation that they are as a victim.
Okay. Mr. Tang, juror 5.
I thought about this so many times. I would be the worst eyewitness. I have a hard time, we go wait like 5 minutes. But.
So be memory recall if you have an issue.
It'd be the credibility of the person that is saying that, I mean, how I feel, how credible I would feel that person would be in saying that they identify the defendant. I know this sounds horrible, but somebody who's like dressed in a business suit and said he was there and saw it versus somebody who is maybe a semi-homeless person. I would factor that into it.
Okay. Juror 4, Ms. Lomax.
Relationship, who they are to the person accused. Is it police officers, the eyewitness, or a friend of who the person is.
And how did that come into play? How did that come into play? Did they know them better, recognize them better, or what?
Well, they have 2 police officers and they're both the witnesses. That's the only witnesses we have. Well, there's maybe some bias there. And it's just his buddies that saw it. So it is some of the time.
Okay. Mr. Barton, you've been quiet. You're getting ready to be on the jury. Number 8.
Just their credibility, you know. A lot of that has to do with personality, job.
Okay. Let's go cheat sheet. Okay. Some extra factors. Mr. Nieto, or juror 16. What do you think about any of those? How do you think it affects if a person who's the eyewitness knows the person, has seen them before? You think that's going to make them more believable or less believable if they've seen the person before and they're trying to identify somebody?
Well, yeah, like they notice them, like they have tattoos or a scar or something, and they can better recognize the person, distance, what they can recall and how they know him, stuff like that.
Okay. Mr. Wiley, you're also working on being on the jury, so juror 15. What do you think event duration means?
How long they saw the person?
I'm sorry.
How long they saw the person, that's all they know.
Okay. And Ms. Coleman, juror 13. What do you think capacity means?
I guess just what they're doing, I don't really know. Eyewitness testimony is notoriously not reliable, so I don't really think it much.
You don't think eyewitness is reliable?
Notoriously reliable, and easily influencing, especially when time is passed.
Okay. When we say they're easily influenced, what about things like after acquired information? What does that do to an eyewitness identification?
Changes how they view the person, their mind sees the person with the issue.
Okay. Mr. Clark, do you think people try to be right about who they say somebody is? They want to be correct in their initial inclination of who someone was?
I think probably most people.
Okay.
There's always somebody that's. So wants something.
Ms. Terrell, juror 11, do you think it would influence you if you only kind of see who you think someone is, and then you later learn other information or given additional images or whatever, more information like, oh, yeah, that's who I saw. Do you think that influences an eyewitness identification or not? Facts you learn afterwards.
Absolutely, I think people could be influenced by police officers and or other people that may give an eyewitness testimony. They can be manipulated and guided, manipulated that every day by commercials. So I do think it can be mistaken in their identity and perhaps, I mean, it could go either way. That's a very difficult question to answer.
Right, especially when you don't know much about what you're actually talking about, right? Juror 10, Ms. Deserter? Deserter. Does it matter if the eyewitness is law enforcement or civilian? And as far as, I'm not asking you who you believe better, but I mean, don't the rules of accuracy apply the same to whoever's trying to identify someone?
Well, the law, circumstance should be the same as the credence we give, but of course, the law enforcement person is going to often be getting these.
And why is that?
Because they would have training.
And what kind of special training do you think they get?
Observation.
Okay. Can you think of a situation that might affect their ability to be honed in on their accuracy? Maybe like flying down on a highway or
Emotion.
a gun in your face?
Yeah, emotion can completely skew what you were observing.
Okay. Juror 9, Mr. Borden. Do you think that it's going to be more or less reliable if you learn that the reporting person was under stress?
I have to know the circumstances, what kind of stress he's under, but for sure, if he's under stress, he may be writing more emotional in his reports than he would be if he wasn't under stress.
Well, let me ask you, because I can't really commit one or the other, because no one really knows what particular situation, every situation is different. But what are some stressors that might make what you think you're seeing less reliable?
Well, I mean, it's a high-speed chase, or said that's gun in your head, or what's going on. There's lots of things that are stressed out. I mean, even at home, you could be stressed out, or not being able to pay your bills, or whatever.
Fatigue. Okay. And juror number 17, Mr. Woods, you're also working on getting on the jury. What about focus? Well, how does focus play into the reliability of someone's eyewitness identification of somebody?
You're tired, stressed out, have stuff going on. I mean, that honestly affects your ability to stay focused. You call certain things.
Okay. Mr. Adcock, What do you think about cross-racial issues? You ever heard of those? What do you think that means?
I mean, if you have some racial bias or something inherent in the background that causes you to see things incorrectly, or some confirmation bias based on, hey, he's in this spot and he automatically, whatever, then just having bias then based on your racial issues, I guess.
Juror 19, do you have anything to add about what cross-racial identification might be?
I mean, it's kind of a hard, say, everybody's different, so people have upbringing being racist to a certain demographics of people versus others. It's all dependent upon, I guess, an upbringing or even like a mindset about.
Okay. Mr. Mitchell, juror 20.
Yes, ma'am.
All right, I'm gonna help you out a little bit. Cross-racial identification is the old adage of, I'm white, all blacks look alike. I'm white, all those Asians look alike. It's a very rude way to put it, but that's what cross-racial identification is. If a person is not of the same race, they aren't able to differentiate between others of that different race. They all look similar to them. Eskimos all look alike. Well, American Indians perhaps, there's so many different, tribal ancestries. Things like that. Y'all follow me on that? That's what cross-racial identification is. Maybe it stems from bias, like some of you have spoken of, but honestly, it's just an inherent thing that we have that we can't see the differences sometimes, right? And that's where the bias comes in. If someone says, oh, that's that's an African Ethiopian person. What do you think of when you first think of an Ethiopian person? Very thin and skinny and hungry, right? Racial bias turns into identification issues. So can you tell the difference between different people if they are race opposite you? Okay? What makes it stand out? Do I have any law enforcement out there? Prior law enforcement? Okay. What did you used to do?
I was in corrections.
Where at?
Lubbock, Texas.
It's juror number 1. In Lubbock? Okay. Do you know the difference between a lineup and a show up?
So we didn't do those in my area, but a lineup, I assume, is when they bring up suspects and then the person behind the glass will be like it was before, and then show up with the people who are standing with the other.
Right. So were you aware that in Texas, if you're going to do like a lineup, that there are certain rules about legislative recently, like a couple years ago, you have to follow a certain protocol and dictate what you did and everything to make sure they're not overly suggestive. Okay. That's because there is some science to doing lineups to make sure everyone looks kind of similar, in those pictures. For instance, if you've got 5 people, 5 photos, in the third photo, the person's face fills the entire photo up, and everyone else is like kind of back, and you're going to draw the attention to the one with the big face, right? Where everyone else has small noses, and then you pick a person with a big old nose. You have to make people have similar features to try to differentiate. So that's why lineups are extremely helpful. That's why you use them on civilian witnesses that are eyewitnesses, right? Has anybody ever heard of a law enforcement officer looking at a lineup after they ID somebody on TV? Anybody seen any of that before? I never have. But y'all agree with me that they're just an eyewitness just like anybody else, right? Whereas, let's see who doesn't talk to us. Juror 21 was Flores, my nurse. A show up, do you think that that's going to be a little different if someone just got robbed, for instance, and you're over at the HEB parking lot here, little HEB, and they detained some people, so they think they did it. And so you're the victim of the robbery, or maybe just a witness, whatever. And someone drives by, says law enforcement, whatever, and they have a person sitting in the back of their car in cuffs. They go, is that the guy? Do you think that's going to be as reliable as someone who actually picks somebody out of a lineup?
Everyone's probably going to be tense and not really as focused as they might be at a water tower. So I would say it probably be best.
Okay, and that just all goes to reliability, right? That's in the province of the jury. It's for jury to decide when they're trying to figure out, did you really see that person? Is that really who you thought you saw, right? Okay. So the second part that leads to wrongful convictions is accusation, false accusations. We said that, right? So Ms. Rayburn, juror 23. You ever been falsely accused of anything?
I'm sure I have.
Never in your whole life?
No, I have no doubt I have.
Oh, no doubt.
No doubt.
Okay, hopefully nothing to rise to the level of criminal offense.
No, I'll run with it.
But just because somebody says something happened, does it make it true? No. Juror 24, Ms. Garcia, you ever been accused of something that wasn't true? Mr. Seagal, juror 32, do you think because someone's accusing someone of a crime that they have to be telling the truth, or same thing? It doesn't have to be true.
But you can accuse anybody of it.
31, Ms. Henderson, how do you feel about false accusations? Do you think they're common? And if they're common, do you think there's typically a motive behind it? Okay. Juror 30, Ms. Anderson. Have you ever been falsely accused?
Oh, yes, but not at a court level.
Yes, okay. And again, just because one person says something happened doesn't mean that's really what happened, right? So, Ms. Rodriguez, juror 29, if you're law enforcement and you get a call in from somebody and you need to go out and help that person, would you imagine that as law enforcement, you have to assume it's true to go do your job, right? Does it mean it's true?
No, not necessarily.
Okay, all it means is you have to go out and do your job based on whatever someone says, right? Okay, and then what would you expect after that? Follow up? All right, so the third thing that can lead to a wrongful conviction, the investigation, okay? Mr. Ibarra, juror 28, super quiet. All right, state asked everybody questions about whether law enforcement does a good job or not. And most of you, I think, felt that, well, sure, our law enforcement, they work really hard. We do think they're humans, right? They're up against a lot right now in today's world. I mean, for the most part, do a good job. But there are those situations where maybe they didn't, whether it be time constraints, stress, just sometimes maybe it's incompetence, or just human error, okay? But that can lead to a bad investigation. It can lead to the wrong person being accused of a crime. Would y'all agree with me on that? Okay. Do we expect law enforcement reports to be accurate? Does everybody expect that all the time? I saw someone kind of shaking their head sideways. That Mr. Sellers? No, wrong. Is it Mr. Adcock? No. Yeah, I'm
What's the number?
I don't remember, it was wrong. Mr. Adcock, you were kind of shaking your head. Are you?
Well, I was like, yeah, I wasn't saying no, but no, I think you expect everything to be as accurate as possible. That's why you do it to write it down.
Right. Yeah, so if you're in law enforcement and you observe something, you're gonna write it down, you're gonna make a record of it, talk to your radio, whatever, right? Okay. Important facts, that's why they wear those body cams and have those communicators, right? Let everyone know what they're observing. What about the depth of the investigation, Mr. Woods, juror 17? Do you think that law enforcement should just take things for what they're worth, or should they go beyond and make sure what they're being told is really accurate?
Yeah, I think that's their duty, is to do the job to the fullest and get to the truth, whether it's hassle or not.
They should follow any leads they have?
Absolutely.
25, Ms. Mueller. What do you think about preservation of evidence? Whose duty is it to preserve evidence of an allegation of a crime? Is it the defendant? Is it our job to make sure that the police kept all the stuff they were supposed to keep? Okay. And who should be punished for that? The defendant who can't defend himself? Because there's missing evidence? Ms. Sellers, what do you feel about the preservation of evidence? Do you think that's really important to you as a juror to know whether that was done or not in a particular case you have to decide guilt or innocence on? And of course, we all know there's other stuff out there. That's just one thing. Mr. Schwartz, how do you feel about law enforcement's duty to preserve all the evidence?
I think it's only one of two things I can use to make my decision. I think it's really important.
Okay. Well, do you think that evidence sometimes can corroborate other evidence? Yeah, I guess it is. Well, if you have one person who says something happened, and then there are maybe other witnesses who saw the same thing, that would be corroborating evidence, right? Perhaps. Or maybe it was recorded by somebody via phone and by video. That would be like corroborating what someone says or sees, right? Okay. So you agree with me that there's lots of types of different evidence that corroborate other people's testimony or other evidence to help you determine if it's good or bad evidence, right?
Yes.
Comes most into play when you're talking about testimony. Did you see a thing? Video is a video, right? But a human, you have to determine credibility, believability, know what you want to believe, right? To their testimony. So would it be helpful to have all the evidence that was available presented to you? Okay. 37, juror Mock. Again, would you expect the defendant at any point in time in being accused of anything to have to go out and preserve evidence? And this juror Ortiz Roland, 38. How do you feel about law enforcement's duty to adhere to the principles they're taught during training, following your own rules, your own protocols? Do you think that's important in their credibility, believability?
Yes, I think it's important.
Do you agree with her, Mr. Is it Susan?
Yeah, I agree. If you're hired to do a job, then you should be pretty well positioned to do that job.
Okay, that's juror 39. What happens sometimes if law enforcement doesn't do their job? What's the end result? Could be a wrongful conviction. And juror 40, when you're trying to figure out the identity of somebody who's committed a crime, who do you think is going to have the best view of who did it?
Eyewitness.
Okay. Someone who's there?
Yes.
Okay. That could be a victim, right?
Yes.
It could be just a bystander, right?
Yes.
And whose job would it be to bring those people to a trial to help you as trier of fact figure out who did it?
Law enforcement.
Okay. Not the defense.
I would say if it would help them, it would apply there as well.
Okay, so let's move along. We talked about backgrounds again, and the personal experience that we have. I already asked some of the law enforcement folks out there. We've got the one we have in the corner, Scott Family, who has influenced his lives and his decision making, perhaps. Is there anybody else who knows anybody local law enforcement, anybody in the Broncos? Of course, yes, Ms. Nicholson. Hill, excuse me, Ms. Nicholson. I'm sure you know.
I work for the sheriff in Travis County.
Oh, you do?
Registered nurse.
That's Mrs. Flores. You currently work in there, or you used to work?
No, I'm retired 10 years.
Okay, so you're very familiar with law enforcement and what they do and what they don't do, and maybe you have some officers potentially.
Wasn't my it wasn't in my immediate purview. However, I did, work with people in that environment.
Okay, I saw some rain hands back there. George, excuse me, 29, what's your involvement with law enforcement? Oh, you're assistant director at TCJ. Yeah, so you have some specialized knowledge regarding the criminal justice system, sentencing, parole, all those kind of things that probably would find their way into a trial. Would you agree with me? Do you think that if you were selected as a juror, that you would be able to set aside that intricate knowledge that even most lawyers don't understand on parole? Do you think you set that aside when trying to determine an appropriate punishment for someone who maybe has been found guilty? You set aside? I've got juror number 18.
Yeah, I mean, I have, in my neighborhood, there's police officers all throughout, so I'm friends with police officers, constable, former deputy sheriff. Yeah, so, I mean, I know that I'm friendly with them, right?
So, and we all, I'm friendly with them, hopefully, because they won't give me tickets when I see them. But, we all work together in this community we live in. And I guess the real question is, if you see a person who takes the stand, that, lives in your neighborhood, there's law enforcement, maybe you had an encounter on the street, they didn't give you that ticket, they gave you a warning or something. Do you think that prior interaction with any familiar law enforcement people you have is going to make you more biased one way or the other towards anything that comes out of their mouth? Okay. I have more hands up. Juror 8, Mr. Barton.
My youngest son was a law enforcement, but he's been out for 6 years.
Where was he a law enforcement officer at?
Denton County.
I'm sorry, sir.
Denton County.
Denton?
Denton.
And was he like a patrol officer, investigator? What?
He's actually a bailiff.
Bailiff, okay. But he's out of right now.
Oh, yeah, he's out of, and our rival is in law enforcement. So,
You do.
yes.
So would you tend to find a law enforcement officer's testimony more credible just because you like them, you respect them? No. Okay. Some people do, and it's okay to have that feeling. And more hands up. Juror 24, Ms. Garcia.
I participated in extracurricular activities, including a lot of dogs. I'm into training like law enforcement type dogs.
Okay. All right, so you have a lot of familiarity. So, do you know Sarver, the person whose name showed up on the screen during the state's board hour, Officer Sarver? Do you know him?
No.
He's the local dog cop.
Most of them that I interact with are from Georgetown and Leander and the city of Austin.
Okay.
I've walked into many rooms with police officers who's like, oh, hey, how you been?
Yeah, okay, pretty good skill you have there. And with that familiarity, is that going to make you, make us start out kind of on the other end of the spectrum? Like we have to earn our case in chief because you work with law enforcement all the time.
Kind of the opposite.
Okay. Not going into detail about it. We don't know what to think of and what we do.
I'm sorry, Ms. Brown. I didn't hear what you said.
I said without going into detail, it's not going to make you affect your decision one way or the other.
No.
Okay. All right. Other hands up. Mr. Sousa.
Yeah, I said that part of Travis County. I've got a friend who went to high school with there, part of AD in Travis County Sheriff's Department.
And will the fact that you have a lot of friends and family involved in law enforcement automatically give you more, give a law enforcement witness more credibility to you than just any other witness who takes a stand? Now that they've been trained, right? We can't disregard people's training, like experts and things like that come in. But do they still have to prove to you beyond a reasonable doubt that they're telling you the truth?
Yeah, but I think I might have more guidance or not guidance, but I might lean a little bit more toward the lawful side of the evidence than the other side.
Okay, so it'd be hard for you to leave those preconceived opinions about law enforcement at the door. You might not be able to be fair to the defendant in the case that hinges on law enforcement's credibility. Okay. Well, maybe it's not work. They always say you're pregnant or not pregnant, or maybe pregnant. So, I mean, you're not sure if it would affect your decision or not.
I think it might.
Ms. Brown, 4 minutes.
Thanks, Judge. Okay. I talked too much, sorry guys. All right, Judge already talked about the bifurcated system, and talked about punishment, the portion of the phase. If someone's convicted, then the jury actually has the right to come in and hear a whole bunch of other stuff that maybe you didn't hear in the case in chief. You get to hear other things and decide what could be an appropriate sentence. Would everyone agree with me that you have to consider all of these types of factors, not just consider one? Is there anybody that cannot consider all those factors in determining an appropriate sentence for an individual? Nope. Is there anyone out here who says, I'm just here to punish a person? If they're convicted, they gotta be punished, if that's what we do. I hope not. All right. Judge already talked about the punishment range. Do we have anybody who's been a victim of an assaultive crime? A crime involving like firearms or car accident, left you in a bad situation? Anybody out here? Because again, this might not be a good trial for you. Mr. Dudley, can you give me those situations aside and that affect your trial? Either there's sometimes a victim of violence or firearms involved in anything.
Yeah, I can say this.
Okay, who else have a hand up? Juror 11?
Yes, my daughter was a victim of domestic violence, and her now ex-husband also committed arson, served 11 years.
Okay.
It was in a different phase.
Will you be able to set that aside and, okay, thank you. Anybody else out there? Juror 44?
I just had, in Gillespie County, an event, my middle son got himself in some trouble.
Okay.
2 years of trial, or a lot of confirmation bias, nepotism, even within the force.
Will you be able to set that aside and hear both sides?
You know, I've got a bad taste in my mouth about Gillespie County, but as far as Hays County, I could.
Okay, thank you, sir. 21, I think it's 12, sorry, it's upside down. Mr. Clark.
I've been a victim of gun violence.
Okay, think you'd be able to set that experience aside and give a client fair trial to hear if there's some type of gun involved or anything like that? Good, thank you. 38 back there. Yes, ma'am. Juror 38.
Yeah, my cousin was assaulted. It was a racial assault.
Okay, I'm sorry to hear about that. Does that bother you?
It does.
Would this not be a good case for you to sit on? If there's any violence involved,
I think I could go through it. I just think also that there's a bias about racial, terms, and I think there are people that unfortunately have, they're attacked more than others because of their race.
okay. All right, the state's gone over the burden very well, so did the judge. Talk a little bit about burden of proof. The judge said there's no definition in Texas. 1 minute, Judge, if I may.
1 minute.
I just want to let you know, this is the side of reasonable suspicion. Officer says, who are you? What are you doing here? Right? You have to answer. Up here is probable cause. It's where they have the right to pull you over your car because they're speeding or something. They think there's something going on or someone's reported that something's happening, right? Then you have the next burden on the chart, which is preponderance. That's the civil lawsuit stuff. I win 51%, you lose 49%, okay? That's overlending, damages. Then you have over here, pretty far over here, clear and convincing. It's the amount of evidence the state has to do to take the kid away from you, okay? Pretty high. The way over here is beyond a reasonable doubt. I just want to make sure you all know that you're here today. When a police officer does their job as well as they can do, they're over here, probable cause, okay? So that's why we have juries. Accusations occur here, and juries occur way down there, okay? So that's gonna be your job if you're put on the jury. So if anybody has anything they want to talk to the judge about, that you feel like you can talk to the whole group about, just put your number up real quick. I think Allison addressed that earlier. If there's anybody else who thinks they might want to talk to the judge, put your number up now. Nobody? Okay, thanks for your attention.
Can the attorneys please approach? Okay, no, what I'm gonna ask you to do is step aside and, because I've already seen
Talking down, please.
Which, it's part of
It's right there on the table. No, I just expect it. Okay, jury, what happens right now is that the parties are going to meet, they're going to confer and discuss some issues. That makes it go faster for us. We're almost to the end. After they come back to me and tell me certain numbers and what we're going to do with them, then you all will go outside. The attorneys will then have 15 minutes to make their strikes. You'll come back in. We'll tell you who the 12 that will be the jury, and you all who are not in the jury will be able to go home right then. So we're getting very close to the end. Just stick with us, and you'll be out of here very soon. And thank you for your patience. Do we have any agreements?
I believe we do. Agreed strike for juror number 7.
Hold the talking down, please.
Agreed.
Just no, right.
I'm judging what?
I said right. To what you just said.
Yeah.
Quick,
I think we're all
let's go
freaked
ahead.
out.
Please tell me all your numbers and you can tell
It's
me
because
if
the
you agree.
tarantulas.
14.
Agreed.
24.
Agreed.
34.
Agreed.
39.
Agreed.
41.
Agreed.
42.
Agreed.
44.
Agreed.
Did you want us to keep going, Judge? I think we're probably outside strike range.
I agree.
Because you're not going to cop charge anyone else, right?
No, I don't think anybody else. Is there anything that would make them eligible?
Quiet, please, quiet.
Not for causes.
When are we moving forward?
There was one person who had to talk about them on that side.
Yeah.
Okay.
Number 61.
Okay, we're not gonna get to. Okay, so there's no other challenges. State,
Nothing additional from the state.
defense,
Just doing a quick review, Your Honor.
You did clean hands. No, you're on.
Yes, mine is clean.
Okay. Step back. And you'll have 15 minutes. All right, ladies and gentlemen, what happens now is the attorneys both have 15 minutes to make their strikes. After they make their strikes, they'll provide them to the clerk, who will give us the list of who will be the jurors. During that time, you all can step outside. It'll be about 15 minutes. We'll open the door. Your cards. Go ahead and set your cards down on the bench right there so you don't take those with you. When you come back in, you can sit anywhere. Don't just sit right there at the aisles to keep so that you're the first one out. It really makes no difference. Make room for all your neighbors. We'll see you back here in 15 minutes. Thank you very much.